The Solicitor-General's office says it has settled more than half of the outstanding 48 claims linked to the Marikana Massacre. It comes as the country prepares to mark the 10th anniversary of the deadly killing, which saw police kill 34 miners during a wage strike at a longman mine in the northwest. Well, for more on the story tonight, we're joined by the Solicitor-General Fhedzisani Pandelani in studio. Mr. Pandelani, good evening to you. Thank you for your time tonight. So quite a lot of work seems to have been done, there's progress, but there'll always be a question, 10 years on, why are we still talking about these payouts and the fact that there's some that still need to be made?
Yes. No, thank you very much for having me, Kathy, and thanks to your viewers as well. It is regrettable that all litigation, in fact, will take such an inordinate period of time, especially when you are dealing with perhaps claimants that are not funded in a way that where you need perhaps expert reports and related aspects. It's a battle. But, of course, 10 years to any practitioner is a period that cannot be countenanced. And for that reason, that is why I took it upon myself when I was actually seized with this matter 6 months after the office has been created, to ramp them up and try to settle them, because a good government is one that in fact looks after the interests of the citizenry, especially the claimants.
Let's talk about this issue of the claimants not being funded and the impact that that would have had on the ability to process the claims and the role that the state has played in that, because obviously these are very vulnerable members of our society and cannot and should not actually have been expected to do all of that on their own.
Well, it is always difficult to mount a claim, especially whether you're looking at government or you're looking at private entities. It's very difficult for a poor person to, in fact, pursue a claim against somebody that financially is muscular. So we do have Legal Aid South Africa, for example, that in fact is intended to fund all the indigent people that have got a valid claim against the state. But from where I sit, that in fact is not the answer. The answer would be where the state is faced with litigation of any sort. We need to look at the merits first and then come up with a policy for early settlement of those matters. As you would know, when you in fact need to lodge a claim against the state, there is always that cooling off period where you lodge a letter of demand, for example. We need to utilize that period to assess the merits of any claim that is made against the state and try to resolve the matter at the earliest opportunity before the claimant is even forced to commence with litigation by way of summons.
Especially because there was no dispute over causality.
Yeah. Well, in such situations, yes. But as you would know, usually, whether the claim is good or not, it is something that is determined at a later stage. Now, what we're coming up with now is to look at causality and the merits first going forward. But these are things that, in fact, were there for an extended period of time, but government is trying to change that, and that is why we've got policies now that talks to matters that are similar in nature with those that we are talking about now. Even though the policies are not designated to deal with the Marikana issue, you still have quite a number of service delivery issues. And any claim against the state, in fact, might be an infringement to the constitutional right of that particular person. So we need to be able to be agile enough to respond to the needs of those that, in fact, feel aggrieved, because the Constitution does protect them.
And, of course, there's a distinction between the settlements we're talking about in this instance and the civil case that is being pursued against the president in terms of personal liability when it comes to the Marikana Massacre.
There is a huge difference. You see, from where I sit, my mandate is to protect the interest of the state. Or alternatively, any person within the employ of the state that was acting within the course and scope of their employment. In the claims that I'm dealing with, I do not have any mandate whatsoever for the president. We're dealing with state departments such as the NPA, such as Justice and Correctional Services, such as SAPS. Those are the entities that we are representing in the main in relation to the Marikana matters. There could be parallel claims that are there. But as I sit here as the Solicitor General, I do not have a mandate to venture into a space where perhaps there is a claim personally, because the President has never approached our office for legal assistance at all. And none of the papers that we are dealing with, in fact, do cite the President as one of the defendants. If there is, it could be maybe insignificant in number, but I've not actually seen the name of the president in the matters we are dealing with. But that doesn't exclude other matters that might be residing in other fora as well.
The 24 cases that are still before the courts, not yet resolved, what are some of those matters about? Give us an indication of what you're dealing with and why it's taking so long to get settlements. So
let's categorize the matters. There were 44 minors that passed on.
Yes.
10 are attributable to police and security officers. I don't want to apportion blame insofar as that is concerned. What we dealt with were the 34, as category A, 34 families that had their breadwinners and were claiming for loss of support to the dependents of the deceased member. In certain instances, you also claim for funeral expenses and related aspects. That's category A. All of those we paid. Were paid about just under 76 million rand, to be exact, on the 34. Then you've got category B. That is arrest, detention, and in other instances, allegations of assault and so on and so forth. Those matters costed the state about 102 million rand. We have settled those. Then, after sifting category A and category B, you've got category C. Category C is generally what matters do we still have that are remaining and what are the reasons why they are in fact unsettled. Now, those are matters that in fact because of the dilatoriness or delay in settlement had to attract the attention of the court. Remember, there is commemoration every day and we're talking about this thing. And so those matters were subjected to what you call judicial court case management, which means the court is now interested as to the speed with which those matters are dealt with. Now, we were allocated from the 25th of July up to and including the 19th of August this year to settle all of those matters. Now, as you deal with a matter-by-matter basis, because the merits are never the same, the claims are not globular in nature. It's not like somebody's claiming 5 rand and therefore everybody will be paid 5 rand. They differ. They sometimes even involve scientific calculations, especially when you're dealing with, special damages. But we made life easy to say we accept all special damages, which means if you come with a hospital voucher, medical certificate and related aspects, we will also deal with those. So we're dealing with pain and suffering. And pain and suffering can never be measured on the same scale. It is something that is actually self-felt by that person. So,
is it the pain and suffering of mostly those who had been arrested?
Some of them had gunshot wounds, but are not falling on category A and not falling on category B. So there are a multiplicity of causes there or injuries that have been sustained. So you can't actually use a one-size-fits-all kind of an attitude to settle those matters. You need to deal with those matters on a matter-by-matter basis. But all attorneys are creatures of instructions. And even the attorneys representing the claimants might actually come and say, well, the offer looks appetizing, and go back to the client to say, well, look, the state is offering so much. You will never move if you don't actually add a cent that that claimant requires, because you are a creature of instructions. If you do that, it means you are acting unprofessionally.
What's the estimated value of those outstanding claims?
It's very difficult to say what is the estimated value, because all of those matters, as we speak right now, the 48, I will only get a report about those by the end of the month. And I've decided consciously not to interfere in the process, because I will actually be dealing with matters that the court is already seized with. So even the 24, you might find that we have actually already exceeded the 24. We're sitting at something more. But I still have to make sure that the liable party within the state, which is SAPS in this instance, affects the payment. Because remember, just signing a piece of paper in itself does not actually mean that you have settled. You still have to go through the arduous process where you make sure that the client department allocates a budget to settle. So to me, it will be called comfort just to see a piece of paper without any guarantees that the money has in fact been paid to the attorneys representing the claimants.
What have you found in that instance when it comes to the departments who are effectively almost third parties here that you now have to try and recoup these funds from?
Well, look, I mean, it's never been easy, especially within the state. And that is why we have actually developed policies going forward, the same policies that we're talking about. Because going forward, state legal consumption will be more easier in a way that, in fact, makes it agile enough to respond. It makes the relationship between my office and the accounting officers who've got the budget to be seamless, in a sense that we can, in fact, as one of the policies alludes, which is early settlement of matters, which is mediation and arbitration. My office can, via the state attorney's office or directly, liaise with the accounting officer of the impacted department to say this matter is not one that we need to defend. Let's settle this matter. You know, Kathy, the 1 rand that you don't settle this year, 1 rand, ends up being 100 rand in 7 years because of escalation and all costs. So it is, in fact, self-defeating for us to delay settlement of matters where matters are warranted. It is only those matters which, in fact, involve cases where people are taking chances, fraud, malfeasance, and related, that cannot be justified. But where a matter, the merits have been considered, I think parties must approach settlement with all humility, with all honesty, and actually finalize the matters.
I'm going to end it off with a broad question to you, because you deal with claims of all sorts. And you mentioned, you know, the issue of service delivery and some of the claims that are coming through from communities there. Do you get a sense that there are lessons that departments are learning from some of these incidents, right? So you take a case like Marikana, that in and of itself became such a big story and such a lesson for the police in terms of what to do, what not to do, and other state departments. So when you look at the kind of claims that you're still having to deal with 10 years on, do you think that there is progress being made in how things, such as service delivery protests, are being dealt with and responded to and handled?
Look, it is a sword of Damocles, but I wouldn't be sitting on this chair if there was no hope to deal with those problems. Because, as you would know, in February, on the 25th of February, the President was addressing the inaugural Intergovernmental National Litigation Forum that is chaired by myself, that in fact, over and above state attorneys, has all legal managers within the state as part of that program. Now, what are we talking about? They were not just sitting there drinking coffee. It means when it comes to dealing with litigation, we need to all put our heads together so that we can also reduce the state contingent liability. You know, any sovereign state which cannot meet its own debts arising from litigation will never be taken serious by any foreign lender of money. So if we don't actually clean that house through all the policies, then it means we'll continuously have service delivery problems. And indeed, the courts have already started pronouncing themselves with regards to service delivery issues. Whether you look at medical legal claims, for example, whether you look at municipalities, it's a big one, it's in billions. So what we are doing now is to try and say, you know, the sooner we deal with these matters, at an earliest opportunity. Of course, lawyers can sit in their offices if service delivery is perfect and there are no issues because you don't have to go to court. So everything else is triggered by either non-service delivery or alternatively something that went wrong, even at municipal level, provincial level. So we need to be agile enough. As I sit here with you now, the task team on the Intergovernmental National Litigation Forum that I chair is also sitting. So I've actually requested somebody to chair that meeting because this is equally important. But we will, in fact, get there because we've got policies, and those policies are something that, in fact, will make us manage and coordinate state litigation in a manner that is seamless.
Well, we need a separate conversation entirely for the medical legal matters because those are just incredible to see how much is being raked up when it comes to claims against the state, particularly where it concerns the health departments. Well, that was the Solicitor-General Fhedzisani Pandelani.